Hello. Uh, so today we are going to study about the jurisprudential essence of BSA. So what is the jurisprudential essence? Jurisprudence means the science of law, the reason behind the existence of this law. Why do we need it? What do we need it for? What logic behind having BSA? We are going to study about this. So, for example, A shoots and kills B. B found dead with a bullet wound in on abdomen. But question here arises: who killed B? If we want to investigate the investigation, if we want to investigate the case, we will first understand these questions. Who killed X? Does X kill himself or who killed A? Does A killed himself or someone such as X killed him? Where he was killed? Whether he was killed at the whether he was shot at a some place and dumped at another place, and why he was killed. From there on only investigation starts. To find out these, to start the investigation, FIR is being filed on the behalf of B, obviously, because he was killed. And from the investigation, we found the accused was it was found that the accused is A. These questions we will find the clues in between the देखो what happens that FIR is being filed, then we will find clues regarding these questions: who killed A, where he was killed, why he was killed. Then we from these clues from the investigation, it was found that the accused is A. Now we know who is the accused. Now the collection of material against A will be collected. Material against A will be collected. Then charge sheet against A will be filed, and the trial will begin from then only. Do you understand? Now when the trial begins, in Indian Evidence Act or Bharatiya Sakshi Adhiniyam, the trial talks about the proving and disproving these clues and the now according to R versus Govinda, there are 5 stages of inquiry. Number 1 is death. Who was dead? B. Was there a person or human being? Yes. Then we will was it a murder? Yes or no, we will find out. And does it culpable homicide not amounting to murder, or is this exception under section 300? These are the 5 stages of inquiry we will study in the IPC. Now, after filing the charge sheet, after inquiry, the prosecution will prove these things: that whether A has caused the death of B, A had the intention to cause B's death. Defense will disproving these things, he will state, defense will state that A was acting in private defense. A is unsound of mind, A is under 7 years of age, accident. He will disproving the things which prosecution will state. Evidence Act allows to basically go through the entire crime scene to connect all dots of the past to understand the crime took place. Okay. The jurisprudential essence of BSA is to do justice between the parties by finding out the real truth of the facts asserted or denied. The Indian Evidence Act or Bharatiya Sakshi Adhiniyam does the balancing of interest between the parties by finding out the truth of the fact. The BSA lays down as to what facts may be proved, what need not be proved, what shall not be proved, who may prove the facts, that is, upon whom the burden of proof lie, and the presumption of facts as well as document, and also how through all oral and documentary evidence the facts may be proved. The BSA is a quest. Quest means search, inquiry, search for truth and justice. It provides for various modalities to establish the truth. For example, cross examination, evidence, contradiction, proving of signatures, export evidence, refreshing of memory, etc. The BSc also stipulates that in the quest for truth and justice, both the parties as well as the court will participate. The court has been given special powers under Section 168 BSA, which was 165 Indian Evidence Act, to ask questions to the parties as well as witnesses. This power of the court is called inquisitorial power of the court. Now, what is inquisitorial power of court? Inquisitorial power of court means the habit or authority to inquire. The court itself also has to be proactive and it has to participate in the process of finding out the truth. Everything in BSA is logical and it is in line with the principles of natural justice. What are the principles of natural justice? Audi altrum partem, nemo judex, in causa sua, interest republicae, sit finis litium, vigilantibus, non dormantibus sua sub judice. Now we will study the rule. Okay, the rule of interpretation in BSA is that of literal interpretation. If there is no ambiguity in the provision, it has to be interpreted as it is. But if there is any ambiguity, then purposive interpretation has to be followed, wherein the larger purpose of BSA will be the key in the quest for truth and justice. Thus, we have to adopt a justice oriented approach. Now we will study the constitutional essence of BSA. What is the constitutional essence? As we know, the constitution is the grundnorm, basic law of the Indian legal system. Its principles are equity, justice, good conscience, non-arbitrariness, reasonableness. Every law has to subscribe to the grundnorm of the Constitution, particularly the essential principles of the Constitution: inquiry, equity, justice, good conscience, reasonableness, and non-arbitrariness. These principles cannot be derogated from. BSA is also guided and regulated by these principles, and no interpretation of BSA can go against these principles.